Hi, my name's Mark Walmer. I'm a criminal justice attorney with 35 years of experience in the Pennsylvania courts. My practice is limited exclusively to clearing old criminal records through the use of pardons and expungements. My website's recorderaser.net. I'll research your record for free to tell you what can be cleared and when. What is today, the 11th?
Well, yes, today's the 11th, but they might not be watching this on the 11th.
Really?
Yeah.
They won't be. We're not live streaming yet. So, welcome. This is my next podcast where I'm going to be interviewing and welcoming Alex Egner of Chipper & Egner, a firm that I am of counsel with. And I wanted to invite Alex to talk about criminal records and how it affects him and his clientele. But first, I wanted to let Alex introduce himself and tell you about his business.
Thanks, Mark. I appreciate that. And I'm very happy to be here today. Been watched a couple of your episodes so far, so exciting to finally be on. So yeah, Chipper & Egner is our firm, and I'm a partner there. We're a general practice law firm based out of Lancaster, but really the majority of our practice focuses on criminal defense work, litigation work, and things related to those fields. We do other practice areas. I do firearms restoration, which is something that we go across the state to do. Whereas some of our other practice areas are really focused kind of in the south central Pennsylvania region and primarily based in Lancaster. But DUIs and other criminal defense work in that region. We also have done some family law, some estate work, a little bit of business work, some landlord-tenant, other general litigation areas as well.
Okay, and we'll make sure to get your contact information and your website up on the video for people that want to contact your firm. You mentioned something that I frequently get calls for. As you know, I'm not going to court anymore. I'm not doing active criminal representation, and my practice is focused exclusively on clearing old criminal records through the use of pardons and expungements. But several times a month, I will get a call about mental health commitments. 302 is mentioned, 303. And that's not a criminal record. And so if it's not a criminal record, it's outside my practice area. But I refer those to you. And I'm wondering if you can talk a little bit about 302 commitments and the process of trying to restore somebody's rights after one of those.
Yeah, I'd be happy to talk about that. So the 302 is kind of the general term or the section that we use to talk about mental health commitments that are involuntary. There's also other sections, so it could be called a 303 if they're there for a little bit longer period of time, or a 304 if it's even longer than that. People are involuntarily committed for a number of reasons, and there's a process that goes through that when someone is involuntarily committed, and that includes a review by a doctor or a treating physician after they are initially brought in on that what's called a 302 application or petition to say this person needs to be involuntarily committed. Then they get some sort of medical evaluation, and then that process can be extended through those other sections, 303 and 304. So when you end up with that associated with your name, that's something that people are always asking, like you said, how do I get this off of my name? How do I get this detached? And since it's not a criminal record, there's a separate process for that. And the basis of that process is essentially we file a petition where we ask your local county judge, hey, come back and review what was done before. And when we ask the judge to review what was done before, sometimes the judge orders a hearing be held. So that person would come and testify. Maybe we'd look at some medical records. Those are very difficult, though. I mean, people are interested in them, but it's a high legal standard because the question for those processes is, what information did the doctor have when he made his decision? So it's not, did this actually happen, or are these facts accurate? The real question is, when the doctor heard this information, did he or she make the right decision? And that makes things pretty difficult for those because generally there was already a process played out where a doctor reviewed this and tried to make the appropriate decision. So you're asking a judge to go back and say that that doctor was incorrect in the decision they made.
Let me jump in there for a second. So back when a person is involuntarily committed, and the doctor comes in, I think within 3 days to make a determination, what's the standard, what's the burden of proof at that point to determine whether the person needs to stay in treatment or not?
Yeah, it is, sorry, I'm sorry, the standard if that person needs to stay or not.
Right.
Yeah.
In other words, what's the psychiatrist or the doctor, what standard are they applying to determine whether the 302 petition has, merit or not?
Yeah, the real question is that person a danger to themselves or others? The involuntary commitments are about immediate danger, immediate assistance. They're emergency situations. Not does this person need some sort of treatment or would they benefit from some mental health treatment in the future? But right now, if this person's released on their own, could they hurt themselves or others?
Okay. Also, the reason I get the calls, and probably the reason you do too, is because there are disabilities that come as a result of a 302 or mental health commitment. What are those disabilities?
Yeah, the number one we get contacted about is firearms rights. If you have a 302, you lose your firearms rights at the state and federal level. And that applies for the 303 and 304 as well. And what's nice, about a separate process to restore those rights is, unlike trying to get the 302 or 303 off your record, the restoration of your firearms rights, while a similar process in its mechanics, a petition followed by a hearing with some testimony, the standard the judge needs to review is a different standard. Not about what happened back then when you had the 302, but right now, are you safe in the community? Are you a danger to yourself or others right now? And so that's a much more achievable standard. Instead of going back and saying, was the doctor incorrect? We say, this person right now before the court, is this person a danger?
So, and that's what's called restoration of firearms disability or something like that?
Yeah, a firearms restoration petition or something along those lines.
Now, if somebody is successful in winning a firearms restoration petition, does that take away the original 302 disability?
It does not. That's why it's a separate process. Instead of having that 302 lifted off your record, like the first process, the second process says, yes, you were 302 and we know that, but you now have a full restoration of your firearm rights, both at the state and then at the federal level as well. It's applied on both levels.
So that full restoration is a full restoration, notwithstanding the fact that you were committed 10 or 15 or 20 years ago.
Absolutely. And it's pretty quick, too, which is great. The judge will write the order, and the state police are involved in this process. They get the judge's order, and the next day I've had people, it's off their record. They're able to go off their background check when they go to get their firearm, and they're able to pick up their firearm the next day.
And you said you do those across the state or primarily Central PA?
Yeah, across the state. We've been out a bunch of counties across the state. I've been out northwest to Mercer County, northeast to Pike County. I'm looking for someone in Greene or Washington so I get the southwest covered. And then, of course, the southeast because we're close there, Philadelphia and those areas. So all across the state, happy to do those.
Good. Well, that's good information.
So I know, Mark, if I can ask you a little bit about your practice area, I know you've made this change to pardons and expungements full-time. 100% of your practice area is that.
Yes.
And what's the difference? What are you enjoying about that?
Well, I have a saying I say to my office staff and everybody else who will listen every day, pretty much. You know what's better than going to court?
What?
Absolutely everything.
Yeah.
I spent 35 years in the courtrooms. And anyway, and I ended up actually feeling a little bit, that's 35 years, whether I was a prosecuting attorney back in the 90s or whether I was a defense attorney. You think you're doing a good job and you're doing the best you can for a client, but usually the Commonwealth has the evidence they need. Usually you're ending up taking some kind of reasonable plea deal, and ultimately what the person gets out of it is a conviction. Mm-hmm. And the convictions, whether they're misdemeanors or felonies, are disabling. And so there's plenty of content out there about the difference between pardons and expungements, and you know the difference as well. But expungements are quick and easy. It's a statute. It tells you what you can clear and when. And I think in our course of work and your course of work, the easiest expungements are when a husband and a wife will get charged with simple assault or disorderly conduct, and neither one of them have any prior record. And if a good attorney gets involved from the beginning, then you go to the preliminary hearing, maybe you prove that there's been some counseling and some reconciliation, and the police and a district justice and possibly the district attorney will agree to, all right, withdraw the charges. All right, go forth and sin no more. And if that happens, the fact that they've been charged with disorderly conduct and simple assault is still a public record. It wouldn't show a conviction, but it would show that charges were filed and subsequently withdrawn. That can be expunged. So misdemeanors and felonies that are brought but then withdrawn or dismissed that have no conviction of guilt, those can be expunged quickly, as well as underage drinking. You're aware in Lancaster County, a lot of the times the pot smokers will get a Section 117 or they'll be given ARD, and once the ARD or the Section 17 is completed, those can be expunged. But pardons are required from the governor to remove every other misdemeanor and felony conviction. And it's a 2-year process that starts with putting together the application, requesting the correct court documents, and explaining why the crime occurred, what you've done with your life since then, and why you're a good candidate. And then we get those filed and track them for the next year or two while the board waits to review them. And then it is nice when somebody gets a pardon from the governor. Now they need an expungement. Every pardon needs an expungement. In fact, it's interesting. September 2022 was File Your Own Marijuana Misdemeanor Pardon Month, which I talked about before. And rumor is, or the word is, that about 3,500 people in a 1 month filled out misdemeanor marijuana pardons. Now, we just had the election 2 days ago. And I think now that the election is over, I think Governor Wolf will be moving forward. The Board of Pardons is moving forward. But every one of those marijuana pardons, when it's issued, is going to need an expungement.
Wow.
So the expungement's the ultimate petition that wipes the record clean, but the pardon is the forgiveness of a misdemeanor or felony conviction that allows it to be expunged.
Wow.
And I like it.
Well, yeah, sure. One question I always get when I'm doing my criminal defense work, and we're talking about a negotiated plea, where someone's actually going to plead to something, it's not just going to come, as a not guilty. Well, they're actually going to plead to something. One of the first questions I get: how soon can I get this on off my record? How do I get this off my record? So one question I had for you, Mark, being in that pardon field, how long? And I know the lawyer answer, right? It depends, right? But how long should this person wait before they come to you and say, "Hey, can I move forward with a pardon?"
That I get that question as well. And really, the tough thing is that the pardon process is 5 people of the Governor's Board of Pardons that are going to review the merits of your application. That means they're going to read about what happened, was there a victim, how bad was the assault, or was it a victimless crime? Like, did you get welfare payments because you didn't declare that your oldest son was living in the house or something? So they take the seriousness of the offense, they look at the time has passed, they look at your explanation for what happened, and then you have to get 3 out of the 5 votes to be recommended to the governor. So the difficult thing is that there is no rule. I got a call from somebody the other day who had gotten out of state. He was serving a 15 to 30-year sentence. I guess he got out at about year 17 or 18, and he's asking me if I'll file a pardon. And my personal opinion is no, because the pardon board doesn't want to be in the process of terminating parole or forgiving crimes before you've served the sentence that was given out by a judge who had jurisdiction over your case. Once you've served your sentence and you've proven that you can be on the street living a law-abiding life, I think they'll be glad to consider it. So there are cases where you can just say it's too soon. I think I used to have a graph. You take the seriousness of the offense. If it's a felony, all right, we're thinking ballpark, you're going to wait 5-10 years. Nonviolent felony, I'm thinking closer to 5. So the more time that goes by since a felony goes by, I think the more your chances increase. If you have a 15-year-old nonviolent felony because you broke into a distributor and stole a case of beer, I think that's a no-brainer. You're going to get the pardon. So at the same time, the seriousness of the offense sort of suggests some amount of time should go by. But then again, if you got caught in college smoking pot 2 years ago, with a 2-year review process, I would say go ahead and file the pardon on that little baby misdemeanor right away.
Well, especially if you're in college, I'm worried about what are my secondary consequences going to be for this plea? How is this going to impact my job future, my education future, my housing future, whatever it's going to be?
And it is just the ability of even misdemeanors or even summary offenses. I get calls from people. Occasionally I'll file a pardon on a summary offense because maybe somebody at Millersville University getting a teaching degree also maybe has a retail theft from Park City Mall from a year ago. And they, with that summary offense that they pled guilty to without talking to a lawyer, prohibits them from going into a high school to complete their teaching requirements. And even though there's a 2-year review process, I can occasionally file a pardon on that summary, which would not be expungible until 5 years has gone by. But if I can get the pardon board to review it in as little as 2 years, and you get the pardon, very small offense, it's holding this person back, then we can file an expungement, maybe probably at the 2.5, 3.5 year mark instead of the 5-year mark. So the complications that roll from these things are just absolutely incredible. And thank goodness for Lancaster County, because they have occasionally made ARD very amenable to either marijuana charges, of course DUIs, maybe other charges. But it's amazing to me the number of calls and emails I get from people that are in foreign counties and they got charged with something, disorderly conduct. You and I know there's a big difference between a disorderly conduct misdemeanor 3 and a summary. Go for the summary. But anyway, a defense attorney will show up. I don't know if they've even talked about a diversionary program. People always have to talk to an experienced defense attorney to try to avoid the conviction, especially if it's a first offense. Yeah.
What's an ARD?
ARD stands for Accelerated Rehabilitative Disposition, and it is a statewide program that the district attorneys can implement as they see fit that basically gives you probation without conviction. It's usually available for DUI, but it's basically a rehabilitative program that gives you probation without conviction.
You know, Mark, and one thing I see all the time is someone has the ARD program, right? So they've avoided pleading guilty or being found guilty of this offense, and they're told, okay, after this is over, the DA is going to drop the charges. So they think the charges have been dropped, they've completed the program, but they're going in, they're still getting denied this job, that job, or people are doing some kind of research on them, and they're still finding out this negative information about them to something they were never found guilty of.
And a lot of people think the ARDs expunge themselves. They don't.
Yeah.
They can be gone in 2 to 3 months with an expungement petition. I recently heard about a county where they will, upon successful completion of ARD, the county will expunge its own record. But that's 1 out of 67 counties. Everybody else isn't sure once they complete ARD if their record's clear or not. And that's why one of the reasons why Record Eraser, my website, one of the things we do is research your record for free, because if a record comes up on the UJS portal, it's there. And once we look at it, we can tell if it needs an expungement or a pardon.
It actually makes me think about juveniles. Do juvenile records need to be expunged as well?
Juvenile records do need to be expunged. It's a very specialized niche area. In general, the rules are if you committed a juvenile offense and you're over the age of 21 and you've been out of trouble for over 5 years, the juvenile record is eligible for an expungement petition, which gets presented to the district attorney, and then the district attorney decides whether or not, looking at the crime when you were a juvenile, do they want to agree that this record can be expunged, or do they want to have a hearing in front of a judge? And so some district attorneys will say, well, look, this might have been a 7 or 8 year old charge, but it was a felony of the 2nd degree. Maybe it was high school robbery where some kid hits another kid and takes his backpack. But the district attorney might want to have a hearing to determine the underlying offense. What have you been doing with your life since then? It's sort of like a pardon review, but it's actually called a Wexler hearing. But yeah, juvenile records. The thing about juvenile records is they will not show up on the UJS public website. They usually show up when somebody applies to an employer that will actually get an FBI or a Pennsylvania State Police criminal history, and those will disclose the juvenile records that aren't usually available online. Well,
I'll tell you, for my clients too, where we see them, is if you would be charged with a new crime 10, 20 years later or whatever, or even recently, your prior record is going to come into that case. The DA's office is going to research and say, have you been charged with something previously? And they'll be able to find that information. And as you know, Mark, in Pennsylvania, charges are essentially cumulative. The more charges you have in your past history, the worse your potential sentence or the way the DA is going to treat you is going to be. Someone who has no prior offenses is going to be treated very differently than someone who has, prior offenses, even if it is that juvenile case from who knows how many years ago that, shouldn't even be relevant.
Well, and the other thing is that it gives the district attorney a talking point, because if you stayed out of trouble for 10 or 15 years, but then you commit another felony and the juvenile record hasn't been expunged, now the DA is like, oh, well, you were a criminal then and you're still a criminal. So we're basically thinking about you as if you have 15 years of criminal activity and you just didn't get caught. So you're right, here comes a heavier sentence and a different story to the defense than if you do clear every old record as soon as possible.
So even beyond those collateral consequences, I see direct criminal implications if you are charged in the future and you haven't cleaned up your past history if you were able to.
Right. I wanted to bring something up about, I did mention that I think every person charged with a crime, even a traffic ticket, you need to talk to experienced defense counsel, because the collateral consequences of traffic tickets to crimes run the gamut. They're not in the same place. Lawyers know where they are and they can advise on it. So people, and most criminal defense attorneys give free consultations, and a lot of them are over the phone. So there's no reason to plead guilty to anything before you talk to an experienced attorney. Another weird niche area of law is where somebody is charged maybe with 15 counts of crime, but then they end up pleading guilty to one. So maybe they were charged with 15 felony forgeries, but then they pled guilty to an M2 bad check. Mm-hmm. That can open the door to what's called a redaction petition. So you can't expunge it because you have a misdemeanor conviction, and you can pardon it, but that's a 2-year process. And, depending on your story, you might have to wait a while to do that. People will ask me, well, can you get rid of those 14 felonies that I wasn't convicted of? And the answer is, it depends. And this is where it's become clear to me that when people are doing guilty pleas, as you and John do, and going into the Court of Common Pleas, if you have that kind of case, you need to see if you can get the district attorney, as part of the plea negotiations, to accept and maybe even note on the record or the plea sheet that the Commonwealth has no objection to the expungement of the 14 charges that are being withdrawn, because otherwise the district attorney who gets the redaction petition might not be the one who did the deal, and then they're talking to their supervisor and they might say, well, no way we want those 14 felonies to come off because insert phrase here. And so even during the time of a plea, as you're thinking about what the person might want to have redacted, see if you can get the DA to say, hey, thank you for null processing these charges. Can we agree that we just scribble in they can be redacted if the guy wants?
Yeah, I can see the impact of that. You're a former prosecutor, I'm a former prosecutor. And as a prosecutor, when you're looking at someone's criminal history, when I see those 15 charges, even though a bunch of them are null processed and there's that one small misdemeanor that there was the conviction on, I do look at that person differently than when I see the sheet with just the small conviction. And that's a mental thing that I think is going to have real impact on people. And I hadn't thought about that redaction petition. That's a great point.
I don't know why I laugh when I start thinking about these things, but I actually saw a criminal complaint, or actually the docket sheet, with over 1,100 counts of forgery.
Wow.
Now, they ended up, of course, taking a plea to like one bad check, 1,100 counts. So we're thinking maybe there's 1,100 checks, maybe whatever, probably a business, maybe a course of conduct. But 1,100, it took up 10, 15, 20 pages of charges that were withdrawn or dismissed. So right away I knew, number one, you had a cop or a trooper with too much time on his hands. Mm-hmm. Because you could also just type 1 through 1,000 counts, instead of enumerating every one of them. Mm-hmm. That's a lot of cutting and pasting. And then the worst thing about it is, as you know, when you go to court to plead guilty, if they weren't going to be null processed or withdrawn, mm-hmm. you sit there while the judge reads through every count, and it's all going to be a concurrent sentence anyway. The district attorneys just need to what's your heart charge? What's your, give me a count or two. What's the sentence? Get it trimmed down, and then allow the rest of the stuff to be redacted.
Well, and I'm even thinking beyond that. I've had trials where it's been split verdicts. I had a split verdict 2 months ago, and I'm thinking, we won on some of the charges. We didn't win on all the charges. And maybe that person's eligible to get those charges that she was not found guilty of off her record.
Well, I'm going to get a chance to argue that very shortly by a woman who went to trial, and not with me, but she went to trial, and a jury acquitted her of everything except, I think, one criminal trespass. She got into a fight with another woman that was bothering her husband. And I filed a redaction petition to get rid of the felonies. Now, she won at trial the peculiar, not to get too wonky thing, but the peculiar standard is the district attorney wants to say, well, even if she was acquitted by the jury, she wasn't proven guilty beyond a reasonable doubt, but whether the charge should be redacted or not depends on whether or not there was sufficient evidence to bring the case to a trial. And so because there was not a summary, there wasn't a demur to the evidence, there was some proof sufficient to go to trial. My argument is a jury listened to it, they're not buying it, so you should get rid of the charge, but the district attorneys can always take a contra position. And I hope we get that one redacted.
And I need the update on that too when it happens. Yeah. I mean, that's incredibly interesting. We see those things, and again, they have those negative consequences on people.
Yeah, the consequences just keep giving and giving and giving. It's when I spend my day now, hours every day, just listening to how people's lives have not flatlined, but just decreased, like earnings, financial. They can't get Section 8 housing with a felony. They're out of prison. They're trying to get a job. The other thing that's just a shame is, as I said, if you go to recorderacer.net, I'll research your record and send it to you. Mm-hmm. From the time we get a client, as a defense attorney, we're always making sure our clients have copies of their paperwork. I don't think they read it mostly. But usually most clients say by the time they've been through the system, they don't know exactly what they pled to. They didn't get a copy of the paperwork. They didn't get a copy of the guilty plea. They went to meet a probation officer who told them to get a job and pay off their fines and costs. And nobody ever gives them an actual copy of something saying, you were charged with a burglary, but it was reduced to a disorderly conduct. Oh, okay. And so what happens is they go into a job interview and they start telling the story. Yeah, what's on your record? Well, I started with a burglary. It's like, no, don't talk about that. I pled guilty to disorderly conduct because I didn't know the park was closed or something. You need to know the story. I
had that exact case a couple weeks ago. Young man, good guy. He got caught with a little bit of something he shouldn't have had. And we worked it out with the officer. We said, okay, he wasn't eligible for a diversion program because of some past stuff, but was eligible for a summary offense. So we got it changed to a summary offense. That's like a traffic ticket. He paid a fine and cost and left. But then he calls me, a week or two later and says, hey, I was applying for a job. They asked me about this summary offense that I just pled to, and I told them, well, it was this, and then they changed it to this as part of a deal. I was like, oh man, you could have just said, I pled guilty to the traffic offense. And so we actually got to go back to the judge and rework out a diversion program for him, which was great. But that was very unique, and we caught it just in time.
Yeah, there's another workaround you should keep your eyes open for. College university towns frequently have little local ordinances about like open container or this, that, and the other thing. And so sometimes a cop will bring an underage drinking charge under 6308, and it's a summary offense, but the person or the defense attorney gets involved, or the police will show up and they'll say, hey, you know what we're willing to do? We're willing to make this a local ordinance and plead to open container. And I'm thinking, no, because the underage drinking charge is expungible as soon as you turn 21. No ifs, ands, or buts. Yeah. That little summary local ordinance charge isn't really clear because the expungement statute will expunge criminal records written under the crimes code. Local ordinances aren't drafted as crimes. And so I can file an expungement petition on a local ordinance, and occasionally a judge will be like, well, I see how this is a summary offense, but do I have jurisdiction to expunge a local ordinance? And of course I say, yes, Judge, you should. But the point is, again, talking to experienced criminal defense attorney might just say, do you know what? We'll keep that open container, or let's make it something else under the crimes code, even a disorderly conduct that could be expunged after 5 years, no ifs, ands, or buts. Try to avoid those local ordinance things.
Yeah, so if I'm a Millersville College student, E-Town College student, Franklin and Marshall student, or wherever, the real important thing is don't try to do this on your own. Call somebody, do the free consultation, get the answers before you go in there and just sign something because you think you're getting a good deal.
Absolutely. And Thaddeus Stevens and Hack and sure. Penn State's local campus. There should probably be a defense attorney like venue or office in every one of these college campuses just to give advice.
I don't know if Penn State will rent me space, but I'd be all about it. So, you mentioned in that last little bit there that you see a lot of these negative consequences, people's lives going down, but you get to see some of the upswing too, right?
I do see the upswings. It's a long, patient process, but I get to watch, frequently, an older guy who committed an offense 15, 20 years ago. He wants his firearm rights back, and he's like, is this even going to work? As soon as they hear 2-year process and a legal fee, they're like, is this even worth it? Because you're telling me there's no guarantees. I need to get 3 out of 5 votes. What if they don't like me? What if I don't get the votes? And I said, look, I understand that, but at the same time, we know a couple of things. One, it's the only thing that can remove it. And two, you have a good story to tell. Especially, breaks my heart when I hear about these men that went over and served their country, did a tour of duty, probably came back with PTSD, but they were holding a weapon and a firearm overseas to defend their country, and then they'll come back and they're not allowed to hunt because of something either before or after their release, and that just doesn't make any sense to me. But the point is, from the moment we get the pardon application filed and they start going through the process, we always give them advice and representation for any hearings or interviews they have during the pardon process. There's usually just 2 hearings. And then at the end, when they're waiting, if they get the recommendation and then they're waiting for the governor to sign the pardon, when we get the pardon and then we file expungements on everything that was listed in the pardon, and then when the expungement goes through and actually clears their record, these guys, one guy the other day just started crying in joy because he's going to be able to hunt with his grandson. Another guy started giggling and he couldn't believe it. And so it is very redemptive. The hard thing is that when you plead somebody guilty, the after effects are immediate and long lasting, whereas the pardon process is sort of like the reward is probable, but it's not immediate, and you get in that and you got to relive your crime for at least long enough to give me a statement or two about how you were involved, and then you have to be patient. But it does work, and it is uplifting, and it's absolutely wonderful. It's redemptive work. And then the guys, I need to follow up with a couple of them a couple of months or a year or two after they get the pardon and see what they think about the process, but I'm usually too busy in the trenches.
Well, that reminds me of the firearms restoration work, right? I mean, it's not the process isn't nearly as long as what the pardon process is, but it takes several months to get through this process. And so I'll tell people, look, you're not gonna make this hunting season this year, but you're gonna potentially make all your hunting seasons in the future. So it's worth that trade-off.
Is the firearms restoration process that is only or exclusively to address the mental health procedures disability? In other words, you couldn't do a firearms restoration hearing if you do have a disqualifying misdemeanor or felony conviction, correct?
Yeah, that's a great question. So in that example, yes, but there are other things that could stop you from having firearm rights that you might need to go through the firearms restoration process for. If it's a criminal offense conviction that's on your record, then yes. I mean, I got to call Mark Walmer. I got to say, hey, get over to these folks and help them get this resolved. But sometimes there's things under the Pennsylvania code that is prohibiting you that isn't a mental health commitment and isn't a charge that is prohibiting you. I've had cases where there are enumerated offenses in Pennsylvania that says you cannot have your firearm rights if you've been convicted of these. But it also says, well, but if it's been 10 years, you completed your entire sentence, you might actually be able to get your firearm rights restored. So there's a secondary process there. I had a case in a northern county earlier this year. We're going through the process. This gentleman had been 302'd when he was 17 years old. You know, he was living with a relative. Things weren't going well. He got in a fight with that relative, and because of that, ended up having a 3-day weekend mental health commitment. And now he's in his 40s. He served his country honorably for the past 20 years in the military, done several tours overseas. I mean, we trusted him to use a firearm overseas. Came home and went to go get his hunting license, get his concealed carry, and was finding difficulty in that process because of this mental health commitment. So we're going through the mental health commitment process. We're getting his rights restored. Great candidate for it. Good story. And as we're doing that, the state police call us to say, and they're the people who respond to these things, their attorney calls to say that when he was 17, he also had a juvenile conviction that's a prohibiting offense. And during that conversation, we said, okay, can we fold this in to our current petition, amend it in front of the judge, and explain the situation to the judge? And because it had been so long, and he qualified under that subsection that said it had been more than 10 years, he had done whatever sentence he was supposed to do, the judge could also restore his rights to that procedure as well. So he didn't get a pardon. It's not off his record, but he did get his firearm rights restored.
Interesting. Also, I think we'll probably wrap up soon, but as you were talking about firearms restoration, I just thought of that classic situation where the husband and wife are fighting and it ends in divorce, but along the way, there's 3 little letters that come up, PFA. And if there is a protection from abuse allegation or petition that's involved, how do you handle those, and is it possible to get firearm rights restored following a PFA?
It is, yeah, that's a great question. So in PFAs, which are, again, those protection from abuse orders where you can't contact that person, there are 2 main types that we talk about. There's the temporary and the final. A current final PFA, that's the problem. If you have the current final PFA that you're dealing with right now, that is what's preventing you from getting your firearm rights restored. If it's a temporary PFA, A, that can be expunged through its own civil process. B, after that temporary PFA time is over, you can get your firearm rights restored as well. That process, a little different than the one we've laid out earlier, but similar enough that, again, talk to an experienced attorney. They'll walk you through how to handle those things.
Okay, let's say there's a PFA and it was a final order, and now the guy's remarried and settled down and living a wonderful life. The PFA is 15 years old, but it was a final permanent order. Is there a way to address that?
Absolutely. Get your firearms rights restored and go move on with your life.
Nice.
Well, good conversation today.
Hey, thank you.
Yeah, I appreciate being here.
It's a good cup of coffee.
I tell you what, one of the best parts about being here today was the coffee.
All right. So one of the segments that I want to do is to keep bringing up stories. These are stories that I get of people writing to me with their records and what happened in their lives. Of course, to them, they're simply saying this is the story. What I'm listening for is, can this be cleared with a pardon or an expungement? This individual was charged in 2012 for drug charges because he was living in a rough neighborhood. The cops just grabbed me thinking I was one of the guys selling drugs. I was confused why they locked me up. I'm innocent. Since then, I've had trouble with my record through the years. Super hard for me and my family. How can I clear my record? I live in a dangerous city named Philadelphia. So I'm hearing he did end up being convicted of something. It's probably a drug offense. Even misdemeanor marijuana charges can lead to a firearms disability. Felony charges, if it's marijuana, can lead to an expedited review. So I want to know what drug it is. If he's been out of trouble since 2012, I think he's a good candidate for a pardon. I'm not hearing anything violent that was involved. And so that's my take on that. just a sort of note to the side is it's not unusual to hear about people that were rousted by the police, rounded up, and charged. A lot of them end up pleading guilty, and they might actually be innocent. The police are occasionally enforcing the law and doing the best they can to keep the streets safe, but it is not unusual, as we know, for there occasionally to be rogue police departments and people that are just rousting neighborhoods and bringing charges, and these convictions end up just rippling down through the decades. So that's a little aside about that. I'm going to try to do a quicker review, so that maybe it's a minute or less. Sometimes I talk too long. This person was charged with not giving a PlayStation back, but I gave it back before I went to court and I still got charged. I'd like to get this off my record. Sounds like a misdemeanor theft to me, unless it was taken from a house. It could be a nonviolent burglary, a very semi-innocent nonviolent offense. I think it's good for review. I want to know, in this case, I don't know what year it is. I want to know what year. What's the story? What have you done with your life since then? When I was 13, I made a bad choice following the wrong people around for guidance. And I possessed a firearm. I never in my life robbed or hurt anyone, with or without a gun. 100% innocent. This system turns me numb. What can I do to try to get my life back? So, that sounds like a juvenile charge. Juvenile records, oddly enough, need to come from the county of conviction. They're not on the public website. You can't see them without writing to the court and requesting a juvenile record. I would certainly think that that would be eligible for review, depending on whether or not it was a felony or not. I don't know if I would be thinking juvenile adjudication in the county of conviction or a pardon from the governor with the 2-year review process. By the way, I answered my own question. The governor can pardon juvenile offenses that weren't previously expungible. So the pardon is always there where the governor has authority to pardon anything, juvenile or adult. And I think I'll do one more. I ended up with a non-traffic summary offense in March 2008. Expungible. Period. This was Pittsburgh. It's now a sealed case. I want to have it expunged, which should be straightforward. It's been over 10 years. So here's what something called Clean Slate did to make my job more difficult. Clean Slate was a statute, a legislation that was passed to sort of hide older non-traffic and criminal offenses. It doesn't erase them. It doesn't expunge them. I like this case. I think it's expungible, but I'm going to need to get a Pennsylvania criminal history to dig it out so that I have enough information to file the expungement petition. I agree it's going to be expungible. More than 5 years, any summary offense is expungible, any criminal offense. And as I said, maybe one more. All of my felony charges on my record. It's been 10 years since my last release in 2007. All of these are nonviolent. They've been affecting me getting a decent job. I bet, you know what? You need a pardon. Give me a call. Go to the website. Get your record researched. I think that's a green light on that one there. So anyway, my name's Mark Walmer. Thanks for watching. I'll try to keep these podcasts coming. Also, I wanted to do an update from the Board of Pardons. The Board of Pardons is going to be holding a 4-day marathon review session. I believe, I'll bring those dates, but they're in December. I believe Governor Wolf is going to issue a couple of thousand pardons on the marijuana misdemeanor cases that were filed in September. Every one of those marijuana pardons is going to need an expungement. I'll be glad to quote a fee on those, no matter what county it's in. Also, I believe that there are a ton of cases that have been waiting for Governor Wolf to review them before he leaves office at the end of the year. As we know, he's not going to be the governor next year. It's going to be Josh Shapiro, with a whole new board on the Governor's Board of Pardons, or at least a new lieutenant governor and attorney general. So I will bring you updates on those as we find out how many pardons are being issued. Every pardon needs an expungement. Go to my website, subscribe to my YouTube channel. This is all I do. I do it all the time. I can't get enough. I just can't stop. So anyway, have good holidays, and stay in touch.